Today's podcast is all about estate planning. So the information I'm about to give is relevant to New South Wales, Australia. It is similar in other states and territories within Australia, but slightly different. And I would expect that it's probably similar throughout the world. So when I talk about estate planning, people freeze up. They think they don't need it. They think estate planning is cursed because they're going to die. It's too overwhelming or whatever it might be. So I really want to normalise estate planning because it is very, very important. What I'm going to go through are the three common documents that we refer to when we say estate planning. Now, I've had clients and friends in the past who have not wanted to use me because of the relationship, because we're friends or family, which is completely fine. But they've gone to get estate planning documents sorted, and the only document that was mentioned to them was a will. The enduring power of attorney and the enduring guardianship was never mentioned. Now, to me, that's negligence. So you can't say your estate planning is done with a will, because the other two documents are just as important as the will. So estate planning for us is a will, a power of attorney, and an enduring guardianship. So the will is a document that comes into effect when you pass away. And in that will, you choose executors, so the people that will work with a lawyer to administer your estate and to make sure that your wishes under the will are carried out. You will have beneficiaries in that will. So the beneficiaries are the people who will benefit from your estate. So it could be a partner, it might be kids, might be a sibling, parents, whoever. In the document, you can also appoint a guardian. So if you have kids under the age of 18, you can choose a guardian for where those kids can, or who they can live with if you were to pass away. Now, things that I have heard over the years are, I don't need a will, everything is going to go to my partner. I don't need a will because my dad made a will and he was perfectly healthy, and a few days after he died. So they're jinxed. So if I were to make this will, I will also die like my dad. It's too overwhelming. I don't know what to do. Pretty well heard it all. We've also had some people do their own wills, which usually ends up with issues. So the do-it-yourself will kits, I don't recommend. They are often signed wrong. They're usually filled out wrong, and they're not suitable in every circumstance. So if you think that you don't need a will because it's going to go to your partner or spouse, generally that is probably what will happen, but it is going to be a lot more stressful for that spouse or for the person or the people that remain to administer your estate, because you die intestate, which means you don't have a will. You also have to think that you have worked really, really hard to get all of your assets, or even if you have minimal assets or you don't consider you have assets, you have worked really hard for what you've got. So why would you not want to make sure that your hard-earned work, so it could be super, could be property, it could be money, it could be heirlooms, whatever it is, why would you not want them to go to the people who you want them to go to? Sometimes as well, we need to exclude people from a will, or we need to consider maybe giving that person something, but not to the extent perhaps of other beneficiaries. So if you were to do a will yourself or a do-it-yourself will kit, that doesn't cater that in. So when we ask the questions to draft your will, we go over and above what is a typical legal practice probably will, because we want to make sure that absolutely everything is covered. Now, coming up to Christmas as well, so it's the end of October at the moment, we get people on the last day of when we're opened for the year, all of a sudden wanting to make their documents. So impossible, it's not going to happen. So if this is something that you need to do, please make sure that you book in either with us or your lawyer to make sure your estate planning can be done before Christmas. With wills and with the other documents as well, sometimes it's too late to make these documents because you might not have capacity to make them. So if you don't have capacity to make a will, you don't have capacity to make a will. There's no backup. There's no other options. You can't do it. The other documents are a little bit different, so I'll speak about them in the moment. We also get those panicked phone calls where I'm laying in bed, I've been told I've got today to leave, or my spouse is in bed, or my dad, whoever it might be, I'm going to pass away within the next 24 hours. I don't have a will. I need to get that done. So those appointments are not always available because we may have other clients already booked in, or whatever happens. So please don't leave it literally to your deathbed to make these documents, because they may not be able to happen and you may not have the capacity to make them. So will is very, very important. Don't assume stuff is going to go to your spouse or your siblings or your kids. It will be much easier and much cleaner for that to happen for your wishes, not the government's, not intestate law or probate law, will law. So will law's not everything, having a moment, but it's to what the government deems where your estate should go to. So usually it's kind of spouse, then it might be kids, then it might be siblings, and maybe parents and grandparents and all down the line. You have somebody in your family that you don't speak to, you might not want them to benefit from your estate. You might have an ex-partner and you haven't done your estate planning since you separated. So there can be just so many different variables on this. So will, very, very important. Please make sure you have one, and please make sure you review it as well. So I generally say, you're preparing your documents for end of financial year, maybe have a look at your insurances, maybe have a look at those estate planning documents to make sure that they are still right. Maybe you have had kids and you don't have a guardian. Maybe you want to swap somebody out. Maybe you have separated and you need to take your spouse off the will. Whatever it might be, if you get married, you need to make a new will. So if circumstances have changed, please make time to schedule in a will appointment. So the other document is a power of attorney, and this document is valid while you are alive. So the power of attorney, I kind of refer to, and I try and make it as easy as I can, kind of say that's like the business end of your life. So that power of attorney can be registered and we can sell property. Your attorney can access your bank accounts to pay bills on your behalf, speak to utilities. It's kind of just the business end, the financial end. In the event that you can't do that on your own. So people will also think, oh, yep, I have a house with my spouse, I don't need a power of attorney. So, which is wrong. So if you own property with your spouse or anybody, and that property is joint tenants, you can't sell and say something happens to the other person. You can't sell that house because you only own 50% and the other person owns 50%. With that power of attorney, that it can be registered and then that property can be sold on that other person's behalf. It is an absolute nightmare if that needs to happen and you don't have that document. And usually when property needs to be sold, it needs to be sold yesterday. So the process is that you have to apply to the tribunal for them to make a decision as to granting an equivalent power of attorney. So the issue with that is sometimes they will only appoint one person. Sometimes they may appoint two. So if they appoint one, and if something happens to that person, you're stuffed. You need to go make other arrangements. You need to go back to the tribunal. You get audited yearly. Any decisions that are kind of large in nature, so selling a property or whatever it might be, you need to get the tribunal's permission to be able to do that. So it is very, very, very restricted. And it's probably better than nothing, but I would not recommend it. If you have the availability to make a power of attorney yourself, that is what I would do. The other document that we refer to is an enduring guardianship. So an enduring guardian is what I refer to as the health end. So you appoint guardians. So the power of attorney, you appoint attorneys to carry out your wishes or to manage the finance end. The enduring guardianship is the health end, and you appoint guardians to make decisions in relation to your health. So where you live, what healthcare you receive, medical, dental treatment, if you need like home services, the health end of your life as opposed to the business end under a power of attorney. There's also a clause in there that says if you're so seriously ill you're not likely to recover, you don't want to be subjected to anything that's unmeaningfully going to prolong your life. Keep me comfortable, but ultimately I'm making the decision for you. I don't want to continue. I want to pass through peacefully. So it's you making that decision for your guardians. So they're not left wondering, do we leave the machine on or do we not leave the machine on? And I kind of refer it to as like a flip the switch, I suppose. It's you making that decision so the people that are left to make that decision aren't scared that they have made the wrong decision. In this case, they're fulfilling your wishes of not being subjected to anything that's unmeaningfully going to prolong your life. So, for example, a machine that breathes for you. You don't want to stress those family members out even more when you're on your deathbed and they're trying to work out whether we keep you alive or whether we don't. Or they're arguing, maybe one does and one doesn't. You don't want that when you are on your way out. That will cause all sorts of dramas, and I'm sure you don't want your family to be split on your death over something like that. So it's not a DNR. There is an advanced care directive, which is a fourth document, which really goes into more depth as to what medical stuff you want and what you don't. Not many people take that up, but there is a next level advanced care directive document. Now, I really want to normalise talking about death, and that may seem really morbid, but I obviously see what happens. And sometimes it's okay, and sometimes it's not, and it is super messy and stressful when that could have been avoided, when you could have maybe have drafted those documents. And I do have stories that flow in on that as well. And I mean, I've normalised it so much in my household. My girls, so they're 11 and they're nearly 13, they know what estate planning is. They know what the documents are. They're completely comfortable with those documents. It's not that I've necessarily told them what it is. They've heard me on the phone, or if they're in the office with me, if I'm working at home, they hear me talking about that. And, they're not shy of going up to somebody, do you have your will? Do you have your estate planning done? For that's normal. And that's what I like. I don't want death to be a taboo subject. And I would love for the process to be made easy for the people who are left when you do pass away, to know that they're not making the wrong decision, and they're not stressing over decisions that have to be made. And what I mean by that is when it comes to the funeral. So you can do like a prepaid funeral. If that funeral company goes under, I understand it's into like an insurance policy type thing. So, you kind of buy at today's coffin and funeral rates, and you might not pass away for a very long time, but you can plan whatever with them. So, a big one can be buried or cremated. It might be, do you want a full Catholic service? Do you not want a service? Do you just want people to go to the pub and remember you? Like, do you want to be buried in your, wedding ring or engagement ring? Do you want to be buried in a particular, outfit? Songs, like what songs? All of that can be really, really stressful for the people who are left to make that decision. And, we will get people that will ring us saying, hey, I've just, mum and dad have just passed away. Did they mention if they would like to be buried or cremated or a song or anything like that? We take as much detail as we possibly can. So we will jot down, do you want to be buried or cremated? Okay, where do you want to go? Or is there anything particular you want to note about your funeral? We don't have to do that, but we do that because we do get those phone calls. So we just, the more that you can have that conversation with your family, the easier it's going to be. So hopefully that helps explain that estate planning process. And please reach out to us if you have any questions at all. Thanks, guys. Just restarting the podcast. Sorry, I just had a delivery show up, so I was trying to cut it short, and then I realised I didn't provide the stories that I was going to talk about before. So with a will, so we have had people in the past not tell us the whole story. So we have had people have a child as a result of an affair, for example, and not tell me that there wasn't a child from that affair. And when that person has passed away, that child has then tried to claim on the estate. So this was a person I didn't even know existed. So it's really important to give all the information possible. Another one is like children who are like stepchildren, blood children, adopted children. That is really important to know. If you're excluding somebody, so say you may not have a spouse or kids and you're leaving it to your siblings and you have nothing to do with a sibling, we need to know that, because that's more information that we have if that sibling goes to make a claim in your estate. So nothing to be ashamed of. When we ask those questions, sometimes the other partner is kind of looking and say, oh, what's the response to that? But we ask those questions for a reason. And that's another over and above service that's included in it, because we feel we can't advise you correctly if we don't know all the situations, and we can't do our job properly if we don't have the information. With the power of attorney, we have had a few urgent power of attorneys where that needed to be done yesterday. So one was where a lady's husband had passed away. That lady had a will, but she did not have a power of attorney or an enduring guardianship. That property had to be sold, but she had no capacity. So we had to apply to the tribunal. It was pre-COVID. Her bank account was going in the red because we couldn't speak to Centrelink. We couldn't access her bank account. The nursing home took her in, but she was borderline getting kicked out of the nursing home because they weren't receiving their payments. We couldn't sell the house to fund everything because we didn't have that power of attorney to sell the property. And the urgent application ended up taking, I think, like 4 or 5 months. It was really bad. They made the family drive her down to Newcastle. She vomited, she soiled herself, she was a complete mess. when she got there, and they made her sit in a room for a while to then come back home and experience the exact same thing on the way home. So that's probably not how you want to do it. And as I said, you get yearly audits. You've pretty well got to justify every decision that you have made. If you can avoid it, it would be suggested that you avoid it. If you think that's a document that you need because somebody is incapacitated, I would suggest that you make arrangements to do that document now, because guaranteed when you need it, it will be urgent. And it's going to be the tribunal's urgent, not your urgent. So the enduring guardianship, you can also apply to the tribunal for, but they generally don't grant them. So they'll do something for the money side, but not usually the health side. And that's where it can get tricky for you. Some nursing homes require a copy of the will, power of attorney, and enduring guardianship. Some doctors require that. I went in for a simple wisdom tooth removal, and I had to provide all those documents, and that was only day surgery. You don't realize you need them until you need them. So please don't be scared about having these conversations, about thinking who you would like. And I would suggest that you talk to the people who you are wanting to put in your will, or your power of attorney or enduring guardianship, because they may not want to be that person. And that's fair enough. You'd rather find out now, but find out now while it can be changed, than needing to use a document and they don't want to do anything. So your executors, your guardians, and your attorneys can be all the same people. They don't have to be the same people. It needs to be somebody over the age of 18 of sound mind. Generally, your lawyer cannot be your power of attorney. It's recommended that we don't. And if you have one that is, I would probably get that looked into, because it's not something we're meant to do. But people may not have the same people on the documents. So it could be, look, that would be really great with my money, but when it comes to my health, they're not going to be able to make that decision. Or when it comes to my health, they're going to be able to pull that plug. With my money, I don't trust them. So, and with the executors, they're working with the lawyers to administer your estate. You can do probate on your own. Probably suggest that you don't, because it's just too much involved and too much liability if you get it wrong. So with the executors, they're working with the lawyers, the attorneys, and the attorneys and the guardians are people that you want to know who they're the best people for that role. And if you're an only child like me, you might run out of people really, really quickly. So really have a think. Maybe there's a close friend, maybe there's a close family member, a spouse and siblings, whatever it might be. There will be somebody that we can hopefully think of, and that will be able to make those decisions for you when that time comes. So I hope now that normalises estate planning, and what we mean when we say estate planning. So it's that will, that power of attorney, that's that enduring guardianship. There's also testamentary trusts, which is also that will component, which is for not everybody needs not everybody needs a testamentary trust, but that's essentially the same thing as a will, just a lot more detailed than a standard will. So really do think about, especially coming up to this holiday season, don't leave it until the day that legal practices start to close, because it's going to be too late. And make sure you review those documents regularly. And each state and territory within Australia is similar. And as I said, other countries would be similar in relation to those documents as well. So depending where you're at. And having said that, if you occupy or have assets in, say, Australia and America, you're going to have to cover both of those assets as well. So it's likely you have to have a will made in America, a will made in Australia, but they need to know that each other exists. And if you have any other old documents laying around, you want to make sure that they are with your new documents, because you don't want those old documents being found and those being adhered to and not the new documents that you have created. So we would suggest that you would provide them to your executors, your attorneys, your guardians, say, hey, here's where they are, here's copies, if you need to use them, here they are. And, having those conversations about what you would like for a funeral. It's prepaid, I want a service, don't want a service, I want this song, I want to be buried in this. It might not happen for a very, very long time, but it does make that process easier. When they're left, when you passed away, and the people who are left need to make those decisions. So bear that in mind as well. But yeah, so now I think I'm done. If you have any questions at all, please do let me know or reach out to your own lawyer to make sure that you have those documents and those documents still suit your needs. So that is Estate Planning 101 for New South Wales estate planning. Hope that helps. Thanks, everyone.